start to our meeting today. Just the key issues for today's meeting is the committee informal deliberations on the Protection from Stalking Bill, consideration of correspondence from the Health Committee on the Abortion Services Safe Access Zones Bill, and consideration of the draft committee report on the legislative consent motion, police crime, sentencing and courts bill, further information on the implementation of the recommendations of the Gillen review, and an update on the preparations for the review of financial processes in 2022-23. I just remind members that they are welcome to use the mobile devices as long as they're in airplane mode, and all devices are muted. This also includes members' tablet devices. They can connect to the Assembly Wi-Fi. Also, that we are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matter under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Can I have agreement of the members for the committee's informal deliberations on the Protection from Stalking Bill to be reported by Hansard? Agreed? Thank you. Agenda item 1 are apologies. I have an apology from Emma Rogan, and just to advise that Rachel, Doug, Gemma and Peter are joining by Starleaf, and welcome them to the meeting, and also welcome Robin, who I understand by unanimous consent chaired last week's meeting exceptionally well, so much so that you would like him back today. But can I just thank him for his help in reference to last week. And before I proceed any further, can I take this opportunity as the chair of the committee and as a friend and colleague to extend our sincere sympathy to Peter on the passing of his dear mother. Our thoughts and prayers are with you, Peter, and we are glad that you've been able to join us today, so our sympathies are with you.
Thank you. Just thank you for those kind remarks. The only thing I noticed, just by way of, I think on the device that I'm using, I don't appear to have a sort of a hands-up indicator, so I may have to physically, if I'm looking to speak, I'll give a wave.
That'll do. Or shout. That's okay.
Or shout, yeah.
Okay.
It wouldn't be like a northern politician to shout.
Thank you, Peter. Okay. Just that we have under standing orders the votes delegated, and Emma's vote has been delegated to the Deputy Chair, Sinead, but we still haven't had any word from Sinead. Sinead Bradley is online now as well. Okay, thank you. Item 2, the draft minutes of the meeting of the held of the 21st of October. That's at pages 5 to 17 of the minute pack, and are we content that the minutes are a true reflection of the proceedings of that meeting? Agreed? Thank you. Item 3, under matters arising. In relation to the Troubles Permanent Disablement Payment Scheme, we have correspondence from Capita. Anthony King has written providing a copy of the feedback on the staff training sessions on the Troubles Permanent Disablement Payment Scheme as agreed during the oral evidence session of the 7th of October. Mr King has also reiterated that he is happy to provide the committee with further updates as the scheme progresses, and to meet with any committee members if they have queries or concerns about the scheme or Capita's other work in Northern Ireland. And the relevant correspondence and related papers are at pages 19 to 38 of today's meeting pack. Item 2 is the tracing the review research report. You'll find that, members, at pages 39 to 163 of the meeting pack for today. The committee wrote to the Department of Justice on a number of issues and concerns regarding the proposals for a joint secure care and justice campus for children, as well as a range of other youth justice issues. The committee also requested a copy of the Department's response to the findings of the research commissioned by a range of children's organisations entitled Tracing the Review, which charts the implementation of the Youth Justice Review recommendations with a specific focus from 2015 onwards. Department responded indicating that the review report had been shared in final version and it would consider it as the strategic framework for the youth justice in further development over the rest of the mandate. The Department also stated that the report contained a number of factual inaccuracies. The authors of the report, which is due to be launched on the 23rd of November in the Long Gallery, have provided their response to the 3 points raised by the Department and a copy of the amended final version of the report. And so just to ask members to note the response on the amended final version of the report, unless there's any other further comment. Thank you. Item 4 is the Protection from Stalking Bill Committee Informal Deliberations, and we will go to do that piece of work now, and we appreciate the indulgence of the committee in relation to this. We have a considerable amount of work to get through in relation to this, so I certainly appreciate your help in trying to work our way through this in the next few moments. If you could turn to pages 166, that is the commencement of the papers in relation to the formal committee deliberations on the Stalking Bill, and they go to pages 337. And also there's relevant papers at pages 3 to 10 of the table pack for also the clerk's memo, which was also emailed to members yesterday. The departmental officials attended the meeting on the 14th of October to discuss the issues raised and the evidence received in the bill and answer members' questions. The Department has provided the text of the proposed amendment to Clause 17, and this can be found at page 260 of the meeting pack. The committee will now undertake its formal deliberation on the clauses of the bill, the proposed amendments. I also advise that representatives from the Department of Justice, Brian and Barbara, will be available via Starleaf if members have any questions or require any further information or clarification, any issues during the informal deliberations. And I thank them in advance for being in attendance today and for the help that they've given to date in relation to our consideration of the bill. The informal deliberations provide an opportunity for members to discuss the issues raised, indicate whether they are content with the clauses and the proposed amendments, require any further information or clarification, or wish to amend the particular clauses, or are minded to reject any particular clauses. If members need more time to consider a particular clause or clauses, the committee can continue its deliberations next week, but the committee stage of the bill must be completed by the 10th of December. Therefore, what we are engaging in today is time limited. Also, just to inform members that when accepting a clause or amendment, members can express views and make comments, and that the committee can also make recommendations, for example, with regards to the implementation of or outworking of a clause, and these will be reflected in the committee report on the bill. If the committee is minded to make amendments to any of the clauses, the purpose and the desired outcome of the amendment needs to be clarified. The committee may then wish to write to the Minister of Justice asking whether she accepts the proposed change and will table an amendment. Alternatively, or at the same time, the committee can ask for a draft amendment to be prepared by the bill clerk for its consideration. The bill clerk, Stephanie Mallon, will be listening to the committee's deliberations today, and if the committee indicates that it wants any draft amendments prepared, then she can provide advice and seek clarification of the purpose or the proposed amendment if necessary. Given advice from the bill clerk to a committee takes place in closed session, this will happen at the end of the meeting or at next week's meeting, depending on the number or the nature of the proposed amendments to discuss. So we will now work through the bill. The clerk's paper set out the purpose of this session and the key issues the committee may wish to consider during the deliberations. And while these discussions will focus on the issues raised in the evidence, there is the overwhelming support for the bill and the creation of a new stalking offence and stalking protection orders. So we'll move then, members, to clause 1. And clause 1 creates the offence of stalking. And just to give some of the key issues that were raised in relation to this clause, they included whether clause 1 is wide enough to encompass all forms of stalking behaviour, including cyber stalking, and in particular whether the list of behaviours provided for at clause 1.4 is adequate, or is there any merit in adding any of the proposals made by a number of organisations to the list, whether the definition in subsection 1.4 should be amended to include any dwelling in which B resides to ensure clarity and ensure victims renting a property have the same level of protection as those owning their home as recommended by NIWAP. Whether also clause 1.4j meets the request by several organisations that the list is non-exhaustive, and this is clearly set out in the legislation. And so maybe there's one issue there that I wouldn't mind raising with Brian, and that is in regards to the clause 1.4, including any dwelling. Maybe, Brian, would you want to comment on that particular concern that was raised?
I must admit, I would have thought if we're talking about interviewing any dwelling, I'm just trying to see where I can find this in the definition. You can see what it is actually in the... Sorry?
Any premises.
Any premises. Well, any premises doesn't require the person to own the premises. So I'm not absolutely sure. I think the principle in writing legislation is you don't have to put in things which are already self-explanatory. So you said you could expand it, but I don't think it's in need of expansion, because entering any premises is very clear. It doesn't say entering a premises owned or rented or occupied. It actually any premises, and that clearly could actually be a person's dwelling. It could be a rented premises. It could actually be an office or other place where, in fact, a person would be for a part of their life or part of the day. So I think it's an interesting suggestion, but I think it's not necessary.
Okay.
The definition as set out would clearly define, would not distinguish between an owner-occupied dwelling, a rented dwelling, a leased dwelling, or indeed a dwelling that someone was visiting or hiring, for example, if they were on holiday and went to a rental accommodation.
Okay, thank you. I appreciate that. Any comments from any other members? If not, then we'll move. And if members just indicate, then if not, we'll move to clause 2. Thank you. Clause 2 creates the offence of threatening or abusive behaviour, and some of the key issues that were raised in relation to this clause was the rationale for introducing this offence and whether it can only be used as an alternative conviction for the domestic abuse offence and the stalking offence, or whether it can be used instead of a breach of the peace offence in other circumstances. And another issue that was raised was whether the course of conduct element should be removed to provide clarity that where there is a course of conduct, then it is always stalking, and this offence should only apply to a single incident to prevent the likelihood of downgrading the offence of stalking. Is there any comments by members? I know we have. Has Rachel been able to? Yes, Rachel has joined us. Rachel, you have a concern in relation to clause 2?
Chair, can you hear me okay?
Yes, we can, and we're delighted that you've been able to join us and trust you're well.
I am okay, yes. Everybody on the bus is fine, which is good. And I managed to get myself to COP, so we're live in the green zone in COP. Just in relation to clause 2, and it was the reasonable person, and I'd sent over some comments to Christine there, but it's clause 2, and I believe it's section 4. Otherwise in the bill, the reasonable person test, it for me is in the third party, sort of the third person. It's more objective. This seems to be worded in terms of a reasonable victim. Now I'm not too sure if that's just a wording or if that's the way that the clause has been set up, but it does read a bit strange in terms of, you know, why is there no B in clause 2, and who is this reasonable person? If it's likely to cause a reasonable person harm, fear, distress, it's not. Why is it not the same as it is in clause 1, say for example, where it's likely to cause a reasonable person? So just like some information on that, if possible.
Thank you, Rachel. Brian?
Yes, I think in fact in both cases we're talking about the test of reasonableness. Now in one actually the commences where a reasonable person would cause a reasonable person to suffer. That's actually the actual recipient of the behaviour. In clause 2 we're talking about defence, and actually that defence is actually whether the behaviour would be seen as reasonable. Now ultimately that may be considered possibly by a policeman or a judge or a number of other people who would, I suppose you could call them as a reasonable person. But at the same time, it's a wide range of people who in fact would be, I suppose, deemed to be reasonable. I have to say this is something which has been produced by the legislative draftsman. I'm very happy just to actually have a conversation with him as to whether there's any advantage in changing that terminology. But I think in both cases, what we're talking about is a test of reasonableness. And in the terms of the actual offence being committed, it's about the reasonable person suffering fear or alarm. So that's really much about the victim. In section 2, it's more about actually who might well be recipient of information about the defence. And then there is a test of reasonableness. Now, I'm not sure adding the word person would actually have made a significant difference. So, Rachel, if you can explain what the difference would be, I'm very happy to give further consideration to that.
Rachel?
Thanks, Brian. Yeah, no problem. It's just in terms of, it's actually clause 2b. So if it's a person A commits an offence, and then go to B, the behaviour would likely to cause a reasonable person to suffer fear or alarm. That seems to me to be putting the reasonable behaviour on is that then implying a reasonable victim? Does the victim have to be reasonable in that for the offence to occur? It's just that the reasonable person test in clause 1 is worded very differently, and I appreciate that it's maybe a different, there's A and B in one, but that does seem to me to read slightly differently than the reasonable person test that we saw in the domestic abuse bill, and then indeed in this bill in clause 1, where it's maybe saying or comes across as the victim must be reasonable in those circumstances. Yeah. If you get what I mean, I may be reading it wrong, but it just reads a bit strange.
Yes, of course. When 1B is very much about A's course of conduct. So in some ways you're talking about different people actually, and reasonable person test is relating to different actions. I'm not clear really that I'm not sure I wholly understand your point. I understand you obviously want to make sure legislation is right, and so do we. So I would say what I will do is I'll have a chat with our legislative draftsman just to see if they're content that this legislation as drafted is not creating any lacunae or any sort of thing. I don't think it is, but at the same time I'm very happy to check that.
And what we'll do, Rachel, as well, is we'll send over to Brian what you had worded in the email that you had sent to us this morning. Would that be helpful? Okay. Okay, thank you. Any other comments? Yeah, thank you. Any other comments from members in relation to clause 2? If not, then we'll move to clause 3. And clause 3 provides that all victims of an offence of stalking will have automatic eligibility for assistance, such as the use of the live links or screens at court when giving evidence in proceedings. And some of the issues that were raised during this was the need for adequately resourced and fit for purpose special measures, the need for special measures to be extended to victims of stalking for the purpose of civil and family cases, and also the need to ensure that the complainants are aware of the availability of special measure options. Any comments from members in relation to that? Gemma.
Thanks, Chair. Yeah, just to reiterate what you said there, it's important that a programme of work is implemented to raise awareness of the availability of special measures.
Yes.
Yeah.
Yeah, Brian, would you want to comment on that?
I made a commitment in previous meetings to that effect. You know, this isn't, we wouldn't have put this sort of thing into legislation, but in fact the department, in discharging its duties and responsibilities when this bill is passed, would see that public awareness here, and indeed actually in some of the other bits of legislation we're putting through, as actually being very necessary. So in fact, it wouldn't be something we put in legislation, but it is something we'd be committed to taking forward as part of actually the implementation of the bill.
Thank you. Thank you very much. Okay, if there are no other comments in relation to clause 3, then we move to clause 4. Clause 4 adds the offences of stalking and the threatening and abusive behaviour as alternative convictions in a trial of the domestic abuse offence under the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021. And the comments were made in relation to this clause, but there were no specific issues that were raised in the evidence sessions that we had. So unless any member has any other specific issues to raise. Okay. Just one issue in relation to clause 4 of the bill was no, I'm sorry, I was going to read something there which I don't need to read. It's okay, apologies for that. Clause 5. Clause 5 amends Article 29(1) of the Magistrates Court Northern Ireland Order 81, the effect of which is to prohibit those accused of the stalking offence or the offence of threatening and abusive behaviour before a magistrates court electing for trial by jury at a Crown Court. And the same really was in relation to this. There was no specific issues that were raised in the evidence session, unless there's any member has any other comments to make in relation to it. Okay, thank you. Clause 6. Clause 6 of the bill gives the definition of the acts and the risks associated with stalking, and just some of the issues that were raised in regards to this was the standard of proof that will apply to the stalking protection orders, the need for adequately resourced stalking behaviour preparatory programmes, the need to communicate with victims and keep them updated, and whether there is a need for the rehabilitation period to be actually factored into the bill, as this will not be dealt with in existing legislation. Any comments that members want to make in relation to that? Okay, thank you. If there's no specific issues to raise, then we'll move on to clause 7. Clause 7 sets out who may apply for an order, what a stalking protection order is, and the grounds on which the application for an order may be made. And obviously, a number of issues that were raised in relation to this was whether the Chief Constable is able to delegate the authority to make the application of the SOAP under this provision, and the need for the views of the victim to be taken into account and for the victims to be engaged in the process. Maybe, Brian, could you just clarify that point in relation to the delegation of power from, because it names in clause 7 Chief Constable?
It's not unusual in legislation to name the Chief Constable. The Chief Constable has the power to actually delegate the responsibility of this to any warranted officer, as I understand it. That's correct, isn't it, Barbara?
Yes, that's correct.
Yep. So, in essence, this would just be a normal phraseology, and it in no way signals that, in fact, the Chief Constable personally has to deal with these. The expectation is the police will actually. We're already discussing training with the police. The police will actually have a training system. They will actually set in place arrangements in all their divisions to ensure that these cases are dealt with properly and appropriately. And when you're referring to actually taking the views of the victim, clearly these cases will start off with the victim coming to the police. They may well, if the police, having heard from the victim, assess the situation as being one where an order would be necessary if stalking is taking place. They see an order would be deemed necessary in advance of a case being taken through the prosecution system and to the courts. This allows the police to actually move to protect the victim earlier. And in that context, clearly they would actually have to take evidence or information from the victim to help them to determine that an order was needed, and indeed actually determine what the nature of the order, what the order might include. So the victim would very much be a part of this, but the aim of putting the police in the place of seeking the order rather than the victim was to essentially protect victims and not to have them to go through this more onerous task of trying to go to the court seeking an order. So this is actually for the benefit of victims, but the victims will be a part of it, but essentially the police will be the drivers.
Gemma?
Thanks, Chair. Yeah, I see in terms of the standard of proof required to grant an interim SPO in guidance or in, I'll start that again. So the proof needed to grant an interim SPO, so this is relevant to 7 and 11, clauses 7 and 11. Could we get some guidance on that, either or get that in guidance or in the EFM?
Well, it is a civil order. Therefore, the burden of proof would be of the lower standard. It would not be beyond reasonable doubt. And the aim of an order is really, in essence, a disruption. It's seen as being a disruptive of behaviour. It could well be it's disrupting serious behaviour, so it couldn't continue while a court case is being developed. It might also be that the actual level of offending might be fairly low level. It may well be it wouldn't actually necessarily go to a court case. It may well be the order itself and the restrictions imposed might themselves disrupt the behaviour and actually stop it. So in fact, there are maybe a number of reasons you'd bring these orders into play. But certainly, in fact, if they are civil orders, the standard of proof would be the lower standard of proof, not beyond reasonable doubt. And that means, it's providing greater assurance to victims, because if it was beyond reasonable doubt, and then you obviously have to go through a much more robust process, and it would mean actually that the victim might well be without this sort of cover or protection during that period.
Okay, thank you, Brian.
Thanks, Gemma. Rachel?
Hi there, Chair. Thank you very much. Just on clause 7, I just wanted to get some further information on ensuring that the deferral of responsibility of these stalking protection orders is not put back onto the victim. And I know this is an issue that was raised with us when we met with the Susie Lampley Trust, and they have anecdotal evidence that orders are not being sought in England because of their cost and their resource. So I know that the department had said that they intend to closely monitor requests, and these sort of SPOs being rolled out 6 months and then 12 months after the regulations are commenced. But is there any opportunity for the department to monitor requests from alleged victims, and if the PSNI are therefore processing them, and how on those SPOs as they are on the bill?
I'm not sure this is a matter for the bill, but clearly I think certainly we are setting up a group to support us with implementation. That will include actually victims groups on that group. I'm sure they will be. They will certainly help us to ensure that we are adequately monitoring things as they develop. I also think I know that our experience in Northern Ireland has been where actually we pick up legislation which has been developed elsewhere, and there are gaps or problems or issues, we are forewarned. So in fact, whereas obviously when this came across, this legislation or similar legislation was brought out in England, I know in fact there are some police forces in England who have produced exemplary systems, and indeed we actually had one of the trainers from one of those Sussex, yes, which was actually commended for the quality of actually their work and support for victims. So we clearly want to learn from the best, but clearly we'll take account of any criticisms which have occurred elsewhere, and that will actually inform our group going forward. So it means in essence we're forewarned, and therefore in fact both us and for that matter victims groups will want to look very carefully at how it's rolling out. And if we felt there was some issue there, we would certainly pick it up with the police very quickly. I have to say my experience from talking to the police on this one so far is they've got a good bit of experience of working in the domestic abuse legislation, with the training which is just, I think, completing about now. But certainly from that, they've learned a lot from there, and they will be using some of the same teams to take forward their own training in this when it comes to law. So one can never say that nothing will ever go wrong. What I can say is, in fact, we're forewarned. We've got a good understanding where problems have occurred elsewhere, and because we're working with victims, we won't just listen to the police service and their feedback. We'll also hear from victims groups as well as the system develops and moves forward.
Okay. Rachel, okay? You content with
Yes,
that?
thank you, Chair. No, absolutely. Just making obviously these SPOs are going to be costing roughly £800 piece. So if there is going to be any budgetary requirements, obviously that's something that would need to be ensured that can happen.
Yeah. Okay. Thank you. Just want to check, any other member, any issue in relation to Clause 7? If not, thank you. Then we'll move to Clause 8. Clause 8 sets out the powers of the court to make a stalking protection order, the grounds on which the court may make an order, and what may be included in the terms of an order. Some of the issues that were raised previously were whether allowing retrospective behaviour be considered as compliant with Article 7 of the European Convention on Human Rights, and also whether there is a risk that 8.4 could be manipulated to enable stalking behaviour to continue. And I know, Rachel, you have a few queries in relation to this clause. If you want to raise those now.
Yes, thank you, Chair. I feel like I'm hogging the meeting.
No.
The issue, I suppose it was last time that we had the department here as well. I mean, 8.4 that for me is still quite problematic, and I just want to get an assurance that if the department looked at the possibility of not having 8.4 on the face of the bill, and would that then would there be any issues of not having that on? I just see that with having SPOs but the ability to not interfere with somebody's religion, education, workplace could potentially continue or be able to be manipulated by stalking perpetrators. So I'm just wondering if that has been considered, if that wasn't on the face of the bill. I also have the second point is on the Northern Ireland Human Rights Commission issues that they raised, and in terms of the retrospectivity. Now, it's my understanding that you could have retrospectivity within new laws if it was civil proceedings but not criminal. So just like some clarification on that, and if that is what this means is that behaviours and events, say stalking events that are happening to a victim now, could well be the basis of evidence going forward once this bill is in and the regulations have been commenced, and a stalking protection order can be issued on events that are happening, say, now or a month ago. So just two issues there, Chair.
Okay,
Thank you.
Well, sorry.
No, Brian, go ahead.
Well, on the first one, really, what the department is trying to do is walk a careful line between the rights of the victim and the rights of the accused. And clearly, we are, in looking at this on prohibitions or requirements, we say so far as is practicable. Now, I think Rachel and I had this conversation at the last meeting. Our understanding and our expectation is that so far as practicable, just to be such as to avoid that conflict. Though it's conflicting with actually essentially rights, we have to recognise that the person accused does have rights, but for religious of not having their religious beliefs interfered with, or in fact attending work. But at the same time, that doesn't trump the actual legislation. At the end of the day, in fact, the prohibitions or requirements, if they essentially that's so far as practical, means if they can actually sort of be managed so they don't interfere with those rights, but at the same time prevent the actual behaviour continuing, that may be acceptable. At the same time, it's only so far as is practicable. So if in fact to prohibit that prohibition conflicts with a person's religious beliefs, but there's no other mechanism for actually delivering safety from stalking, then in fact it would go ahead. It's not a question of just saying that their religious rights or work takes precedence. Essentially, the offence takes precedence, but certainly if the order can be managed in such a way that in fact it can provide the victim of protection while still allowing that person to exercise their human rights for worship or for work, then that should be taken on board. So I think in fact, whether it was there or not, I think in fact, whether this clause was in the bill or not, it would essentially this sort of consideration would have to be given anyway. It's actually better to have it in where you say that phrase, so far as practicable. That makes it very clear that the preeminent responsibility is actually to protect the person from stalking, but subject to that protection being delivered, if it's possible to allow the perpetrator or the accused's rights for worship or work to be protected, then that would be a consideration. But certainly it's secondary, not the primary consideration. On the other one about retrospectivity, Rachel, you couldn't just go repeat that, could you? But I've maybe missed the beginning of that, so in fact, I want to make sure I captured you wanted correctly.
Yeah, no worries, Brent. So it is on, sorry, just get this up here, the exact, so 7B, it's basically what the Human Rights Commission had raised, which is about, is there a danger of setting a precedent of behaviours that are occurring now before this law is enacted? And using that as evidence, because obviously we can't say for the domestic abuse bill, we'll be prosecuting in a year's time for behaviours now. That's a criminal offence. But in terms of using behaviour that is happening now for civil proceedings, which I understand these stalking protection orders to be civil matters in the magistrate's court, can that? So is that what this bill is creating with the stalking protection orders? That because it's a civil matter. And civil proceedings, we can actually use behaviours and stalking behaviours that are happening now. So victims could possibly get the police to apply for a stalking protection order as soon as this bill is enacted and this regulation is commenced on SPOs for behaviour that has happened prior to the bill being enacted.
Well, our expectation is the behaviour, because these are civil orders. Certainly our legal advice is in fact that previous behaviour can be taken into account and considered. At the end of the day, it would be different perhaps in a criminal offence, but even there, when you're talking about stalking is a series of behaviours which obviously take place over a period of time. The fact when it comes to these orders is in fact where when the order is being made, certainly behaviour which has preceded the legislation could be taken into account. I mean, that's Barbara, you want to add to that?
No, well, we had legislative competence provided by DSO on the bill, and they had also outlined that such an application under Clause 8 may have taken place before the coming into force of the provisions, and it didn't impinge on any Article 7 of the Convention.
Yeah. So in essence, in fact, our legal advice is very much that there's no impediment to that behaviours occurring before legislation came into force being taken into account, and that wouldn't interfere with the person's human rights in this instance.
Okay, Brian, thank you very much.
Thank you. Brian, can I just clarify the point in relation to the issue that was raised by the police about how the order would be served? I know in your response you had said that Clause 17 guidance requires the Department of Justice to issue guidance to the Chief Constable. Will that clarify that point of concern that they had raised, where they were asking for clarity regarding how the order would be served, and can this be in an ex-party manner without attendance of the offender or the alleged offender or in their presence? Are we right to say that will be clarified in the guidance that will be issued?
Yeah. Okay, Andy, you want to just go back on that one?
Yeah, I think we touched on this the last time, Chair, and yes, from memory, and I'm sure Hansard will confirm it, our understanding was that we could include that in the guidance just to make absolutely clear how and when the police could make, how they could make or serve the orders. Okay. So yes, we're happy to make that commitment that it will be looked at as part of the guidance.
Okay, thank you. Okay, members, if we're content with clause 8, there's no other issues that members wish to raise, then we will proceed to clause 9. Clause 9 sets out the period of time for which an order has an effect, and there were no specific issues that were raised in the evidence session in relation to clause 9. So unless there's any other members, any other issue to raise, if you're content. Okay, we're content, then we'll move to clause 10. Clause 10 sets out how the stalking protection order may be varied, renewed or discharged, and who may apply for these measures. And one issue that was raised was whether, given the appeal provision in Article 143 of the Magistrates Northern Ireland Order 81, rather than on the face of the bill, this should be highlighted in the explanatory and financial memorandums to the bill to ensure the perpetrators of their or their representatives are aware of their right of appeal. So that was the issue that was raised. Any other comment that members want to make in relation to clause 10? Rachel?
Me again. It was the same comment, Chair.
We're going to start charging you, Rachel, but don't worry.
That's fine. That's okay. No, the clause 10. It is just about the appeals process. I know this was raised in the House in second stage. Mr. Alistair, I believe, was querying that, but it's just with regard to other legislation that has reference to appeals, such as the Family, Homes and Domestic Violence Order. It's 1998, Section 39. Makes specific reference to that, and that's with regards to making of the county court the making of an order or refusal to make of an order. So it's just to query, why is it not here? Other protection orders got reference to the appeals process, and just if I don't mind if it's not there, but is the department satisfied that it does not need to be there because it is in other legislation that make orders?
Brian?
I think the short answer is yes, we are. Clearly, either the Chief Constable, or indeed a person against whom the stalking protection order is made, can apply to the court of summary jurisdiction to vary, renew or discharge the order. So in fact, that in effect gives the person the capacity to go back to the court if they felt ready to challenge or test the order. So I think, bearing in mind this is a civil order, not a criminal order, we feel this is actually sufficient.
Okay, any other comments, members? Okay, there's no other comments, nobody indicating. We go to clause if members are content. Go to clause 11. And clause 11 sets out a description of an interim stalking protection order and the powers of a court to summary jurisdiction to make an interim order, who may apply for an interim order and what may be included in the terms of an interim order and the duration of that order. And there were no specific issues that were raised in relation to this, other than, I suppose, in regards to what Rachel had mentioned earlier in relation to clause 8. Rachel, do you want to comment on that?
Thanks, Chair. No, just the same comment on 8.4, whether the limitations and the sort of as far as practical, it's just the same issue that I had, but I think that's been covered in clause 8. Thank you.
Thank you. Okay, if there's... Yes, Brian, go ahead. Yes.
This is the interim one. The aim of this interim order is where actually it would be an interim order, not the main order, because in essence it would be where you found the police felt there was actually very serious risk and a situation where they couldn't wait for a slower process. So this would be more of an exceptional line where there was very clear concern about the safety of the individual, and it was felt that an interim order could be brought in more quickly to give them that protection. So it should be seen in that light. Obviously, it's not. It wouldn't be replacing the main order, but at the same time, it's one of those ones where necessary, actually, it is actually to protect the individual. So I think, in fact, I think that's certainly why we've got it there, and I think in many ways it mirrors what's happened in what's said in this clause.
Okay, thank you. If no other issues or members are content, then we'll go to clause 12. Clause 12 sets out what details must be specified within the terms of the order or the interim order, and the procedural details on the operation of the bill in a court of summary jurisdiction. So there was no specific issues that were raised in the evidence received. There's no comment. Any member? No, thank you. We're content, then we'll go to clause 13. And clause 13 provides that it is a criminal offence to breach the terms of an order or an interim order without reasonable excuse. It will be for the court to decide what constitutes a reasonable excuse in a particular case, and it raises some of the issues that were raised was whether the maximum penalty or summary conviction should be 12 months rather than 6 months for breaching the order to bring the legislation into line with England and Wales. In the written response, the Department indicated that it considers the penalty or failure to comply with the notification requirements as currently drafted to be consistent and proportionate. And obviously, Brian, that raises for probably myself and some other members whether or not, how do we draw a distinction between what we have in England and Wales and what we're proposing here, and yet we say that it's proportionate and it's consistent. It's 12 months in England and Wales, and we're proposing 6 months here.
Mr. Chairman, as you know, we actually have a devolved administration. Therefore, our legal system and our penalties and offences are very similar to in England in many respects, as indeed they are to Scotland and other places. But at the same time, they're not identical. When we're talking about it being proportionate, in essence, we have through, through common law and past practice, come up with some incentives, including that 6 months, and for this sort of summary offence, which has been enforced across quite a number of laws in Northern Ireland. So for consistency, it would be unusual for us to actually depart from that to follow a 12-month model, which is in England for this one offence, not for others. So to a reasonable degree, the responsibility of my department is to both look at our own laws, but also advise other departments as to what constitutes a broadly proportionate response to different levels of offending. This will be consistent with other bits of legislation across the criminal justice system, and as such, we didn't think that there was a sufficient argument to suggest we should actually depart from the norm, which would be a 6 month penalty in this type of case.
Chair, if I could just briefly add, you may recall that I mentioned this during the last evidence session, that although the legislation in England and Wales may reference 12 months, there's a piece of underpinning legislation which hasn't been commenced in England and Wales, which means for all practical purposes, the maximum sentence that can be imposed in England and Wales is also 6 months. And it's because of the different underpinnings in the two different jurisdictions. So although for all practical purposes, as Brian says, our maximum sentence is 6 months, a lot of English legislation, in fact a great deal of English legislation, will reference 12 months, but the maximum penalty is read as 6 months because this other piece of legislation, which is quite old, hasn't yet been commenced, and there's no indication that it is going to be commenced at any point in the near future. So they are directly comparable as it stands at the moment, even though the references are to two different maximum periods in the two different pieces of legislation.
And is it the case, is the maximum tariff, because Brian, you have mentioned other read across to other pieces of legislation where this would be the case, in the outworkings of that, is the tariff 6 months, or do we find ourselves in a position where the tariff is 6 months, but actually in practicalities, most of them only get 3 months.
Now, the maximum sentence for Northern Ireland purposes is 6 months.
Yes, but yes, maybe 6 months in terms of what the tariff says it should be. But what a judge is the judge mandated to give the 6 months, or has the judge the discretion to say, well, actually, it'll be 3 months? And has there been any practice or any analysis that tells us that that is what really happens in real terms?
The judiciary make judgment based on the evidence before them in the court. Where you've got a maximum sentence not exceeding 6 months, clearly they have the capacity to give a shorter sentence. But it's very much dependent on actually the circumstances and the evidence presented. And so, in essence, the judiciary are independent of the department. The department sets the tariffs, the maximum levels. Within those, the judges are ruled by precedent, common law, by some guidelines, sentencing guidelines put out in a number of cases. But in essence, it's a matter for them to assess what constitutes the appropriate sentence based on the facts presented to them at the time the case is being heard. So what we can say is we have the capacity to give 6 months, but the judge will obviously look at all the facts of this case and make a determination of what constitutes the right sentence given the circumstances.
Okay, thank you. Any other comments in relation to clause 13? If not,
Chair, can I just add one small point? Yes. To make it absolutely clear? The sentence in England, although the legislation allows for a sentence of up to 12 months, what I'm saying is that it's not that a sentence of 12 months can be given and that effectively means 6 months. It is directly comparable with the Northern Ireland situation in that the maximum sentence that can in effect be given in England and Wales is a maximum of 6 months.
Right, okay.
Because the other legislation hasn't been enacted.
Okay. Okay, thank you for that. Okay, there's no other comments in relation to that. We're content in relation to clause 13. Then move to clause 14. And clause 14 requires the defendant, subject to an order or an interim order, to provide certain personal details to the police before the end of 3 days, beginning with the date the order comes into force. And the issues in relation to this are largely covered by operational issues, so there was no other comments that any members have to make in relation to that. Content? Thank you. Clause 15 sets out where and how a defendant must notify the police, how notification must be acknowledged, and the police powers to verify and identify the defendant when they attend a police station to notify. And again, this clause is largely covered by operational issues. If there's no members, any comment to make in relation to it? 10. Thank you. Clause 16 provides that this is a criminal offence to fail to comply with the notification requirements without reasonable excuse or knowingly to provide the police with false information. And the key issues raised in relation to this clause were similar to some of those that were raised in relation to clause 13. It was in regards to the maximum penalty in regards to the 12 to 6 months, but I think the officials have covered that in their previous answers, unless there's any other members, any other comment to make. Content. Brings us in, members, to clause 17. It requires the Department of Justice to issue and publish guidance to the Chief Constable about the exercise of their functions under the second part of the bill. This envisages that the statutory guidance will provide information about the procedure for the applying for the Stalking Protection Order, as well as providing a practical toolkit for the police to use when making the application. Obviously, some comments were made regarding the guidance, but no substantive issues were raised in the evidence. The committee has already asked the Department to bring forward an amendment to implement the proposal by the Assembly Examiner of Statute Rules that the guidance should be laid in the Assembly, and the Department has provided the text of the proposed amendment for this, and that can be found at page 260 of today's meeting pack. So if there's any question that members have, Rachel? You still there? Do you hear us, Rachel? Hello? Nope. Seem to have lost Rachel. Okay, maybe I could just read what Rachel sent in an email earlier on today in relation to that. It was, in the issuing of guidance, I need to clarify that the departmental amendment only covers guidance to be issued on the bill and the SOPs to the PSNI Chief Constable only. I'd wish to ask the committee to consider asking the department to expand this narrow scope of guidance. Guidance should be for everyone on this bill, as it was for the new offence of the domestic abuse. Brian, do you want to comment on that?
So I'm not quite sure I'm not quite sure what Rachel means by everyone.
The guidance will be published, Chair, which
Yes,
means it's
okay.
available to everyone. Laying it in the Assembly doesn't increase the circulation of the guidance. You know, it doesn't increase the scope of those who will have access to it. Okay. And by publishing it, we're making it available to anyone who has an interest.
Yes, essentially that would be our normal practice, and as such it is available to everyone. Clearly, I think we would read that as actually meeting Rachel's concern, because obviously we're giving it, we're laying it in the Assembly, but we're also publishing it. It means it's generally available.
Christine?
Yeah, I think perhaps in Rachel's absence, I'll try and clarify. I think the issue she was raising was that the guidance only covers SPOs, whereas the guidance for the domestic abuse offence covered the actual offence and understanding of that, etc. And I think that's what she's getting at, is that she's wanting to question why the guidance doesn't cover the stalking offence as well as SPOs, rather than just focusing on SPOs.
I think actually I'm just being reminded that what we would publish would also be an annex which would be showing the operation, and we'll pick up a number of those points. Okay. Yeah, I'm not sure this is one which needs to be in legislation, but I understand the point about making sure people have a good understanding of in fact, what the law is, indeed how it might apply. Yeah. So in fact, I think in a published document, I think we would have an annex in that which would cover a number of those points.
Right. And what we'll do, Brian, is in relation to that one, we'll also send you that over to you in communication so that you have it.
That would be very helpful.
Okay. Okay, thank you. Okay, if there's no other comments in relation to clause 17, and that brings us to clauses 18, 19 and 20, and these clause 18 defines various words and phrases used within the bill. Clause 19 sets out when the provisions will come into force, and clause 20 gives the short title of the bill. Content? No comments to make, thank you. Members, that concludes the informal deliberations on the clauses of the bill, and obviously there was a wide range of issues that have been raised in the evidence, and they are covered. The list of the issues for members to consider are at paragraph 12 of the clerk's memo, pages 3 to 10 of the table pack, and the department has provided its written response to them in the tables issued for today's meeting. So, members, we want to consider those list of issues and whether or not there is anything else that we want to raise with officials. Is there any other comment to make in relation to that? Okay. Then maybe could we just raise a couple of issues, Brian, before we let you depart, and and give it obviously in the domestic abuse bill there was a number of issues that were eventually read across and put into that legislation, the mandatory training, the data collection, and the requirement of the department to have the operation of the Act monitored or reported on. Is there consideration being given by the department to do the same in relation to this bill?
I think, in fact, we are looking at picking up all those points, but we're not proposing to include them in the bill. Just purely because, in fact, I think I made at the last couple of meetings when we talked about this a number of commitments about what the department would take forward. You know, getting a lot of sunlight here. Yeah, we certainly have made a number of commitments as to what we will do about moving these things forward. We have an implementation group set up which brings together all the key players. We're just bringing the victims groups into that now. That will actually help guide us through the implementation. And certainly as part of that, I would have thought all those issues would be on the agenda of that group. So I think that should provide the committee with sufficient assurance that this is both being dealt with seriously by the department, but also we're not just talking to ourselves and like-minded people. We're bringing the voluntary sector in as well, as indeed we have at every stage of this bill. I think one of the notable factors of this bill has been that we have worked very closely with all the voluntary organisations concerned with stalking from the outset, and certainly we've engaged them in training and other sessions as we've gone along. So that would be the sort of model we'd be taking forward. And all those issues will be picked up as part of that. But certainly I don't see there's being a necessity of including specific reference to these things in the bill, not least because the sort of detail you need to actually progress those would actually be significant. And now I'm not sure we'll still be working through those issues with that group in the coming months.
Any other member have any other issues? Okay, members, if there is no other issues that we want to raise at this stage, then we'll bring this part of our consideration of the bill to a conclusion. Yep, everybody's complete. Yes? Okay, so we're going to bring this formal part of our proceedings to a conclusion. Thank you for your help in relation. Can I thank the officials for their attendance today and the time that they have given and the help that they have been in relation to today's proceedings. Thank you very much.
Thank you.
Thanks, our pleasure.
Thank you. Okay. Yes. Yeah. Rachel, have you any other comments? Are you back online again?
I am, Chair. Would you believe I'm hiding behind a stand? I've been given a plug. I'm not too sure where we left off there, Chair, but I had some issues just about the issuing of guidance, and it was just for the Chief Constable rather than for everyone. So I'm not too sure if that was covered. And then there was a couple of other ones, just things that weren't in the bill, but I'm happy to take your direction to see where we're at with that so I don't start going off on one.
No, that's okay. Well, what we can do is, in relation to some of the issues, we have agreed with Brian that we would forward communication to him, and I think that we will forward that communication to him, and we can deal with some of these at next week at the beginning of the committee. Christine?
Rachel, I think on the guidance one, we've agreed that we'll forward your comments to Brian and they can reply. I did try to articulate, I think, what you wanted, but we've agreed to write on that one, and they'll come back to us. On your proposals, Mervyn had asked Brian to comment on the issue of training, data collection and reporting requirements. And Brian reiterated their position that they have given commitments on all of those, but at this stage they wouldn't be intending to cover them in the bill. So that was where that was left, and then you've just come back on. So.
Thank you, Christine. Obviously, I think Sinead Bradley and Doug will know, obviously, the issues that were raised during the domestic abuse bill and how crucial guidance, training and data collection and reporting were to myself and also then the committee, and we did take them forward as committee amendments, and it's certainly something that I would wish to explore if possible and if agreeable. I just, again, if we put legislation in that people don't know about and we don't know if it's working, how will we know to come back to it? I'm more than happy to go into detail on those things, but absolutely if the department want to come back in writing just on the guidance, I think the guidance being just for the Chief Constable is probably not wide enough and a very, very narrow scope for me anyway.
Christian, should we bring the girl from the bill office at the beginning of the meeting next week? Consider, because this point has been raised a number of times, and I don't think we get a satisfactory answer in relation to why in the domestic abuse bill we had the three elements of the amendments were acceptable, but they're not prepared or they're not considering to do the same in relation to this piece of legislation. What's different about this as opposed to the domestic abuse bill? Kristen?
Thank you, Chair. Yeah, I think the domestic abuse bill, obviously the committee brought forward those amendments,
yes,
and then eventually the department, I think, took them on board. I suppose if the committee is minded to look for amendments or new provisions in the bill relating to the data collection, the training and reporting on the same basis as the amendments that were brought forward and agreed for the domestic abuse bill, we have the option. We could, we're writing to the department on some issues in the bill anyway. We could put the question to the department whether the Minister is agreeable to bringing forward similar amendments in those three areas. And if not, then the committee could bring forward their own amendments again, as we did the last time. If the committee is content with that approach, we could ask for a response by next Thursday so that we know whether we need to prepare draft amendments. We can also arrange for Stephanie to be on standby so that if necessary she can brief the committee.
And the other, do you want also, should we include the other part in relation to the scope of the guidance in relation to just being narrowed to the Chief Constable?
Yeah, we're going to write on the guidance, and I think there was a couple of other issues earlier on to do with some of the earlier clauses where Brian had agreed to provide further clarification. So we'll write on all of those and ask for a response for the meeting next week and put them back onto the agenda for consideration. But is the committee content that we, in the first instance, ask whether the Minister is prepared to bring forward amendments in those three areas?
We'll deal with this first. Are we content on that basis? Agreed? Okay, Sinead Bradley, apologies, I'm just seeing your hand up now. Sinead, go ahead. You're muted, Sinead.
Sorry, can you hear me okay?
Oh yes, I can hear you now, loud and clear. Yep.
Yes, just to add to Rachel's comments there, I do think this is a crucial piece of work that's missing, and I've no doubt it's going to be visited, but I would really impress upon all members that I think the success on the previous bill was the fact that it was agreed at committee and it was a committee amendment. I think that, to be fair, did get the department were then very much aware that the parties were all in agreement on this, and I think if we can get to that same place on this bill, it'll be most helpful, because it is the weight of the bill when it comes into operation, to know how successful it is. All that reporting and training is essential. So I noted at the outset of this, you did say, Chair, that Stephanie from the Bill's office was listening in, and I therefore think it was Stephanie actually was one of the drafters and worked with us well on the domestic abuse one. So I do think it would be helpful to do that, to put on record that the committee would be minded to pick up this piece of work if the department weren't. But that is the first, I think it is the correct way to go forward, to offer the the department the opportunity to do this work, and then to let it be firmly known to the department that the committee will be on standby to do exactly what we did in the previous bill. Okay. And I have no doubt Stephanie will help us in that end. But thank you, Chair.
Okay, I think that's an agreed way forward. Agreed? Thank you members for...
Chair.
Yes, Christian?
Can I just check with Rachel? There was one other issue I think you'd wanted to raise with the department about a stalking register.
Yep.
And we haven't covered that. So I'm just wondering if there's a specific question on that you would like us to include in the correspondence to the department. We can do that.
You're just happy that we ask in relation to the provision or whether they've considered a stalking register?
That's right.
Yep.
Thank you.
Okay. Thank you. Okay, thank you. And Rachel, just in case we lose contact with you again, thank you for your help and have an enjoyable time in Glasgow. Even though you did go by boat, which is uses a lot of diesel to get there, but anyway.
Much better than flying on a short-haul plane, Chair.
You'll have to plant a few trees when you come home.
Oh, don't worry, I will.
Thank you. Okay, members, can we move on then to item 5? And thank you for your help in relation to that. There was a lot to get through there. Item 5, which is the Abortion Services Safe Access Zones Bill, and its correspondence from the Health Committee. And you'll find that on pages 339 to 413. And obviously this was an issue that was raised following the presentation at the meeting on the 12th of October, and the matter has been referred to the Health Committee to undertake the committee stage of this bill. As aspects of the bill are relevant to the Justice Committee, it invited the bill sponsor, Claire Bailey, to brief us on the 21st of October. The Committee for Health has now written inviting views and comments of the committee on the bill. The Health Committee has also written to the Department of Justice and the PSNI and has provided copies of the correspondence for information. The justice elements of the bill relate to the creation of a series of obligations on constables in relation to monitoring and enforcing of safe access zones and the creation of the new criminal offence to the associated penalties. And so what we are asking is for us to agree that we would ask the Department of Justice for a copy of any of the correspondence it submits to the Committee of Health, and to specifically comment on the proposed new offences and the penalties and whether they are in line with the current sentencing policy, to assist the Committee's consideration of the justice elements of the bill and to inform any response that we wish to make, and also to ask the PSNI for any response it submits to the Committee of Health, and to specifically comment on the powers provided to the police to enforce safe access zones and any potential resources or financial implications. Agreed? Thank you. Agreed. Further comment? Thank you. Okay, item 6 is the Police Criminal Sentencing and Courts Bill Legislative Consent Motion. That's at pages 415 to 439 of today's pack. And the committee agreed that at its meeting on the 21st of October that it was content with the proposal to extend a number of the provisions within the Police Crime Sentencing and Courts Bill to Northern Ireland by way of legislative consent motion. The draft report setting out the committee's consideration of the LCAM has been prepared for agreement, and any typographical or formatting errors in the report will be amended at proofing stage before it is circulated to MLAs and published on the committee's website. And are we content with the amendment to draft the report? Agreed? No comment. I'm just making sure that there's nobody. Okay, thank you. I need to then go through this title page, so I need to go through this bit by bit, so if you just bear with me so that we can get this. The title page and the contents are the committee membership and powers page and list of abbreviations. That gives us all that detail. And I'll put the question to the members. Are the members content that the title page, contents page, committee membership, powers page and list of abbreviations page stand part of the report? Agreed. Background section. This section refers to paragraphs 1 to 4 of the report. Are members content that the background sections of paragraphs 1 to 4 stand part of the report? Purpose of the legislative consent motion section. The purpose of the legislative consent motion sections, paragraphs 5 to 13 of the report. Are we content with the purpose of the legislative consent motion section, paragraphs 5 to 13? Content. Then we have the committee consideration of the legislative consent motion at paragraphs 14 to 45 of the report. Are the members content that the committee consideration of the legislative consent motion sections 14 to 45 stand part of the report? Content. And then the conclusion section, paragraph 46. Are members content that the conclusion section of paragraph 46 stands part of the report? Content. The appendices, they are at, I just refer members to pages 435 to 439 of the meeting pack, which lists the items of inclusion in the appendices 1 to 5 of the report. So I can put the question to the members, are we content that the appendices stand part of the report? Agreed. Now we're clear that the draft minutes of this meeting for inclusion in Appendix 1 to enable the report to be finalised, and the draft minutes will be replaced by the final version of the minutes once agreed by the committee. Can I just seek your agreement that the report be published on the committee's web page and issued to all MLAs and the Minister of Justice? Agreed? And then just to advise members that the committee staff will notify members when a date for the debate of the LCM will be scheduled, and no doubt you want to clear your diary and be part of that on that occasion, a riveting event in the chamber. Okay, thank you for your help on that, members. That brings us to item 7, which is the implementation of the recommendations of the Gillen Review into serious sexual offences in Northern Ireland. You'll find that on pages 441, 476 of today's pack. At the meeting of the 30th of September, the committee considered a written update from the Department on the progress to delivery of the implementation of the plan for the Gillen Review recommendations in relation to serious sexual offences cases. The briefing paper set out the current position and the future plans for the main programme work streams and outlined the current position regarding funding and resources and the work of the Education and Awareness Group. And the committee agreed to request further information on a number of issues. The Department has provided the additional information, which includes how many of the recommendations currently underway will be completed before the end of the mandate, details of what the recommendations require, legislative cover, and the position regarding the voluntary protocol to expedite serious sexual offences cases involving children under 13 years of age. And just ask members to note the additional information provided by the Department unless there's any further information or clarification that members require. Thank you. Item 8 is the review of the financial process in 2022-23. You'll find that at pages 478 to 509 of today's pack. And the Department has provided an update on the progress with the preparations for the introduction of the review of the financial processes in 2022-23 and advised that the Finance Minister will be bringing a paper to the Executive on this in November. The review aims to improve transparency in public expenditure by aligning as far as possible the structure of budgets, estimates and resources accounts and the current implementation date for the first set of main estimates under the review is 2022-2023 financial year. That's just to ask members to note unless they have any further information. As a former Finance Minister, I'd be glad to see that happen. Item 9 is correspondence. There are 9 items of correspondence at pages 511 to 756. And unless there's any specific issues, I have nothing to raise in relation to correspondence. If we're content to act on the items of correspondence as set out in the cover sheet. Content? Thank you. Item 10 is the Chair's business. Just a couple of things to raise briefly. One is correspondence from the Assembly Speaker to the Chairperson's Liaison Group. You'll find that at page 758 to 764. Chairperson's Liaison Group has provided the information to all statutory committees a copy of a letter it received from the Speaker regarding the legislative pressures on the Assembly until the end of the mandate. Speaker is due to meet with the Chairperson's Liaison Group to discuss the issue. The committee has previously considered a paper that has been provided to the CLG for its meeting on the 28th of September outlining the current work pressures facing the committees, particularly dealing with multiple bills, and it's just for members to note that. I think we're well aware of the pressures that are on in relation to that. Item 2 is the raised digital strategy. The Chairperson's Liaison Group has asked that the Assembly Research and Library Service digital strategy is brought to the attention of all committees, and this can be found at pages 765 to 773 of today's pack, and just ask members to note. Item 11 is any other business, and if there's any other business, any member, Sinead.
Thank you, Chair. No, Chair, just think, given the letter from the Speaker and I think probably this committee is the committee with the heaviest volume of legislative programme. I stand to be corrected in that, but I believe it to be the case. And I just wonder if the Department or the Minister has been in touch with the Speaker to just safeguard the passage of some of these really critical bills. I wonder if that conversation has happened, if we could ask them if it has, and what reassurances they've been given. Thank you.
Okay, agreed. Agreed. Thank you. Thanks, Sinead. I think that is one of the biggest challenges. If you were to look at the whole list, how would you prioritise them? But obviously, there are people who are waiting on legislation coming from this House, particularly in relation to what we discuss here in this committee, whether it's the domestic abuse bill, the stalking bill, all of that impacts and impinges on people's lives in a very profound way. So it's a very valid question to raise. So we will write to the Minister. Thank you for that. If there's no other items of business to raise, can I just remind members that the next meeting of the Justice Committee will take place on Thursday, the 11th of November at 2 p.m, and that will be in the Senate chamber. And can I thank you for your time with us today. Thank you for those who joined us, and wish you a very enjoyable evening. Thank you very much.
Thank you.
Thank you.
Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.